Welcome to Nuts and Bolts of Arbitration, Spotlight on ICDR Rules. I'm Belinda McCauley, Executive Director and CEO of the Beverly Hills Bar Association, and I'm delighted to be here today to introduce our speakers, Fernanda Flores and Yasmine Lahlou. Fernanda Flores is the Director of ADR Services, North America and Energy at the International Center for Dispute Resolution, which is part of the American Arbitration Association. She holds an LLM in Alternative Dispute Resolution from the USC Gould School of Law and has extensive experience in mediation, arbitration, and regulatory legal work across public and private sectors. Based here in LA, she's recognized for her leadership in advancing innovative approaches to international and energy-related dispute resolution. Yasmine Lahlou is a partner at Chaffetz Lindsey LLP with more than 25 years of experience in international arbitration and litigation. Fluent in English, French, and Italian, she's represented clients across a wide range of sectors, including energy, construction, engineering, and finance, in proceedings under the ICC, ICDR, LCIA, UNCITRAL, and ad hoc rules. Trained in Paris and admitted in New York, Yasmine has arbitrated numerous cases and regularly advises sovereigns, corporations, and state-owned entities on complex cross-border disputes. And now let's get started.
Hello, it's a pleasure to be here with the Beverly Hills Bar Association. And our goal today is very practical. We want to demystify international arbitration and show you how it operates, not as an abstract international concept, but as a real lawyer-driven dispute resolution tool that you may already be encountering or soon will in your practice, and through contract, cross-border transactions, or foreign counterparts, as we live in a very interconnected world. We love international arbitration, but we brought this agenda, with the goal to bring the main tools for help understand better how works international arbitration. We're going to talk a little bit how and why parties choose international arbitration instead litigation. Also, we'll bring you a brief overview of the ICDR, who we are, how we fit within the AAA, and what distinguishes us from other arbitral institutions. Also, we will spotlight key features of the ICDR rules, focusing on provisions that matter most to practicing attorneys. And after that, we'll turn to the importance of a well-drafted arbitration clause. And this is where many disputes are won or lost, even before they ever begin, and we'll highlight essential drafting considerations and common pitfalls. We will explain the arbitral award and how and why ICDR awards are enforceable across borders. And of course, we will look ahead the future of ADR, including how the AAA ICDR is integrated innovation and AI-driven tools to enhance efficiency while preserving due process and party autonomy. So let's start. Why international arbitration? Yasmine, what do you think? Why we should choose international arbitration?
Hi, Fernando. Hi, everyone. I'm very pleased to speak to you, even though not live. You want to go to the next slide, Fernanda?
Sure.
So there's several reasons that international or U.S. businesses opt for international arbitration rather than litigation. The primary one is enforceability of the award, nearly universal enforceability of the award. The reason being that in 1958, the United Nations promoted the adoption of the so-called New York Convention on the recognition and enforcement of arbitral awards, which now has 170 signatories. And in 75, the Inter-American States Organization adopted also the Panama Convention, which mirrors the New York Convention, but for Latin America. And what happens is that under the New York Convention, if you have an award, it's nearly a universal currency, which is almost certain to be enforced wherever the award debtor is found, because the convention provides for extremely limited grounds to deny enforcement and recognition, and imposes the burden on the award debtor to establish the existence of those grounds. We can discuss them further later. And the thing is, there is no comparable international treaty involving the United States for judgments, for court judgments. In 2009, the United States joined the so-called Hague Convention on Choice of Court Agreements, which allows for the enforcement of judgments. But unfortunately, it has limited traction, and the United States has, in any event, not ratified that convention. So if you want something enforceable worldwide, you have to opt for international arbitration. Other key features is the expertise. Most arbitrators are lawyers, but they all have different focuses, and they know certain industries, customs, and practices, and will have a quick understanding of certain features, certain contracts, joint operating agreements. For Los Angeles, the customs in the entertainment industry, oil and gas, and things like that. And that is because you can choose the arbitrator, or you can tell the institution that when they offer names, they should be looking for certain individuals with specific skills. Arbitration, if you opt for arbitration, then you enjoy broad latitude in organizing the proceedings. That it's flexible and allows the party to opt for a pretty efficient process if they want to. Of course, some parties may try to counter that, but that's when the role of a powerful backbone tribunal comes in to streamline the process to the extent necessary. And one related feature is that this can become more cost efficient if you have less discovery and less sort of motion briefing than in litigation. I don't think that that businesses opt for international arbitration for cost reasons, but there has been an immense focus by the institutions over the past years to create mechanism to reduce costs and time in international arbitration. On discovery, you can take a look at Article 24.4 of the ICDR rules, which clearly sets forth a standard for limited discovery, where you really have to identify the documents you want and why you need them. And also 24.10 of the ICDR rules, which says, and I quote, depositions, interrogatories, and requests to admit as developed for use in U.S. court procedures generally are not appropriate procedures for obtaining information in an arbitration under these rules. So these are clearly the exception, and the burden would be on the party seeking those to demonstrate why they are necessary. And I can tell you this nearly never happens. Because arbitration is also a commercial business involving a large amount of institutions, that they have an incentive to be innovative and offer new tools to the users to attract users and for them to opt for an institution over another. And Fernanda will tell you a little bit about that later in the presentation, about sort of technological innovations that enhance the efficiency. Finally, it's two more points. International arbitration has evolved to adopt some of the features of litigation that are the most attractive. It started a few decades ago with more and more institutions and national laws recognizing that arbitrators can issue interim measures. Then there was the institution of the emergency arbitrator that can step in on an emergency basis before the time it takes to have a full tribunal. And you have other mechanisms such as summary disposition mechanism when someone submits a manifestly unmeritorious claim. And finally, you have sort of the neutrality of the arbitrator, since you are not in anyone's domestic court. But obviously, when you're looking for an arbitrator, sometimes you will appoint one that has familiarity with your legal culture or is a national of the same country. There is the issue of whether the presiding arbitrator of the sole arbitrator should be of a nationality that is different from that of the parties. Yes and no. Some institutions expressly require that the arbitrator be of a different nationality than either side. The ICDR don't say that, but you can ask at the time that you ask the institution to give you a list of candidates that you would prefer that they be neutral. Next slide.
Yasmine, can I just jump a little bit and bring some data regarding the cost saving and efficiency? And this is another thing that makes parties to go to international arbitration and not to litigation. So we have our infographics with the data from 2024, as we don't have our infographics from 2025 yet. So in claims below $1 million, the median average time for the award was 10 months. So you can see how is faster international arbitration if we compare with US litigation. And if for claims above $1 million US dollars, the median average time is 21 months. So this is a data to consider when you're thinking where you want to take your case. Here we go.
A few more points. One important feature of international arbitration or arbitration in general is that you can be involved in the selection of the arbitrator either by identifying them directly or providing qualifications profiles to the institutions that will seek to identify the proper arbitrator, the proper candidate that parties then can discuss and select. Arbitration is a private mechanism. This is not open to the public, and it can also be confidential. By default, arbitration is not confidential under the ICDR rules. The ICDR rules require that the institution and the tribunal maintain the confidentiality of the proceedings and not disclose anything about the proceedings, but the same obligation does not apply to the parties except with respect to documents produced in the arbitration. So if the parties want the arbitration to be confidential, they should say so either in their arbitration agreement or more likely when they negotiate the procedural order with the arbitrator. As we were saying, you usually get a faster resolution because of your dispute, since your tribunal is really focused on your dispute and in theory does not have a huge docket. This is not necessarily true because most operators look for experienced arbitrators and they have a heavy docket. But in any event, under the ICDR rules, once the arbitrator closes the hearing, closes the possibility of introducing new evidence, then they have 60 days to issue their award. And finally, for procedure for disputes below $500,000, you can opt for so-called expedited proceedings, and there will be a much faster timeline, and the time limit for the award will be 30 days from closing of the proceedings. And these expedited proceedings apply for disputes, mandatory apply for disputes below $500,000, or the parties can opt in for larger disputes. To you, Fernanda.
Thank you, Yasmine. So now I'm going to talk a little bit about International Center for Dispute Resolution, ICDR. So AAA, the American Arbitration Association, was founded in 1926, and this year we will celebrate 100 years. And with time, they realized that they needed they will start having like international disputes, and they're like, okay, maybe we need to create a division. So in 1996, ICDR was founded, and right now we manage all cases that present an international component. The primary office of ICDR is New York City, but nowadays this AAA has 26 offices in the US and in Singapore. But the ICDR staff is in Houston, Chicago, Miami, Los Angeles, and Singapore. We have a very global and multilingual team with attorneys from Brazil, India, Mexico, Russia, Singapore, Spain, Kenya, and of course the US. And I think we have one from Romania as well. And these attorneys, they are trained in civil law and they have also common law backgrounds. And another thing that I want to highlight that make us different from other organizations is that we are a non-for-profit institution. And in a very simple language, that means basically after we pay all staff and everything, we put our earnings in a foundation and this foundation has a very beautiful initiative to help other organizations, institutions, also nonprofits that share the same ADR principles and creates an impact in society. So far we have granted and donating around $8 million in projects like that. So this is very, very interesting. And why ICDR when you're thinking about your international arbitration dispute, right? So we have been a pioneer in the design, introduction, and implementation of innovative mechanisms in arbitration and mediation. For example, we were the first institution to introduce emergency measures of protection. We realized that some cases they had urgent matters. So we created this as an equivalent that we have in the civil court. And this is very effective for protecting the right of the parties. We also, in 2010, we created an online platform to file and manage cases. So we don't need to send mails anymore, and the case can be completely managed through a website that is very user-friendly. And I think this advances a lot, especially when you're talking about international parties. Also, we implemented AI enhancing tools to support case management and the parties and the arbitrators. Also, ICDR administers cases under its own ICDR rules, as well other AAA rules adapted to each industry for cases with international component. So for me, I have international ICDR cases that we administered under the construction rules, under commercial rules, under healthcare rules, under energy rules. Actually, under energy doesn't have like specific rules yet. Oh, maybe I'm telling like something for the future. I'm disclosing something for the future. And we also manages cases under the UNCITRAL rules. The ICDR rules reflect the best practice in international arbitration. As Yasmine was saying before, the limitation of discovery. This is one of the things that we understand for the international arbitration is not the most appropriate practice. So this is one of the best practices that we adopt. And we are a trusted institutional administration because we provide experienced neutral case management to ensure the procedural integrity and fairness. So the parties and the arbitrators will count with a dual background licensed attorney to help them and to make sure that the case doesn't have any arbitrary from the arbitrator, and the parties that they don't need to deal with some administrative cases because they will have the case administrator to deal with that. Yasmine, do you have anything to add within your experience with ICDR?
I mean, going back to the point you raised on discovery, the rules reflect best practices, and the best practices are really a compromise between civil law and common law countries. Civil law countries do not have historically discovery in their process. So there was a compromise where there is some discovery, but not the tools that you find under US litigation, and you don't have sort of the extensive document discovery that you would see in the US, but instead you have to identify a specific category or specific documents that you're after. But of course, if that goes back to the procedural flexibility we were talking about, if the parties want extensive discovery, they can agree to it, they can put it in their agreement. I understand this is very much the case in the entertainment industry on the West Coast, where parties do not necessarily look for that less discovery, but what they're really looking for is a private forum where they can have a quasi-US litigation, but before a private tribunal.
Yeah, and you're talking about this, remember like some IP disputes as well, that they want confidentiality, right? They don't want to disclose to the world what is happening with the IP. Okay, thank you. So right now I'm gonna talk a little bit about ICDR rules, and I'm bringing some spotlights. So here is like a roadmap how an international arbitration case works. And again, some people, they say the case starts with the clause and agreement, right? So here, but this is not completely true because the parties can agree after. So it's not mandatory that to go to arbitration that the parties need to have a clause before it happens, right? So the parties can agree after that. So here's like a very easy roadmap that starts with the clause agreement. Then when there's a breach, then the party files the request for arbitration. Then the case will assign to one case administrator. And then we're going to have the administrative conference call, the arbitrator selection, the procedural hearing, writing submissions or the briefing phase, information exchange, evidentiary hearing, and then the award. And the spotlight I want to bring, it's here, the administrative conference call. This is a very important tool under my view. I want to hear Yasmine opinions after, because sometimes the parties draft arbitration clause like a long time ago. And the administrative conference call is a very important meeting. The parties will meet with the case administrator to confirm what is they have in the agreement, or if some things still make sense, right? And I'm going to give an example, one of my cases. So the clause was drafted and they want the place of the arbitration to be, I don't know, California, let's say. But then the parties change the main locale, the main place, and now they are in Texas. So they changed the locale with the administrative conference call, and that was very important for them in terms of costs and efficiency. And then the arbitration selection, absent agreement, the list method with rank and strike. So we honor the party autonomy, and we want to avoid administratively appointing the neutral decision maker, because we believe this is the party process. So they determine not to be in court, right? So they want to be in the arbitration. And so the case administrator will build a list according to the expertise and requirements that the party disclosed to us in the administrative conference call. With that information, the case manager, the case administrator will create a list with the most suitable arbitrators, and then the parties will be able to rank and strike. After that, when we receive the list from the parties after the review, we're gonna fill up in our system, and the system will come up with the most suitable arbitrator. So I think this is very interesting and fair because we're not privileged any party. The parties will kind of decide that together with a rank strike, very not arbitrary system. And if you have any question, I can explain a little bit more after. Our arbitrators are compensated and basically on hourly rates. So when we create the list and send to the parties will have the arbitrator resume. And there they will see the arbitrator's experience, how is their rates. So these give the parties the discretion to decide how much they want to pay for the arbitrator regarding their qualification. We also encourage concurrent mediation and arbitration. And this is a very interesting tool, and I see great results with that, because sometimes the parties are not ready to do a mediation before the arbitration. But when the arbitration starts and they start exchanging documents and exchanging other points and see where they are at, sometimes they wanna try mediation before that. Or the opposite is also true. Sometimes the parties try mediation, and in the mediation process, the exchange and the argument prepare them for where they are at in arbitration, and the arbitration runs smoothly. So this is a very interesting mechanism that we provide in our rules for the parties. One of our principles is transparency, and the fees that we have reflects that. So the parties will have previous access to the fees. We have a fee schedule in our rules, and they're going to be aware of how much they will expend in the arbitration. We also have the ICDR Administrative Review Council, and this is a very interesting tool that we provide to the parties to internally solve some disputes. Not disputes, but like small disagreements between the parties within the arbitration process. So this council, it meets once per week. So, and we have very experienced and seniors vice presidents. They are with the council, and they help decide as like not appellate court, but it's kind of like that. If we're gonna compare with the court system here in the US, they help to decide how is the best way to proceed with the arbitration. And again, the positions and interrogatories as developed for use in the US usually are not appropriate for international arbitration under our rules. But again, as Yasmine mentioned, the parties can agree with an extensive discovery process. And the review of the award, I think this is another thing that makes ICDR a very international and neutral institution, because we want to keep the quality of the award. So it's not going to be only the arbitrator who will review the award. The award is going to go through the case administrator and then some superior, senior case managers and vice presidents to make sure that all the requirements and the awards in a good shape to go out to the parties. Another ICDR spotlight is regarding the tribunal authority and case management. So the arbitral tribunal has.
Fernanda, if I may step in, if we can go back to the prior slide, just to give a little bit of flesh to the Administrative Review Council. They don't engage in the substance of the dispute. Sometimes it happens that a request for arbitration is based on a pathological arbitration clause that has some ambiguities whether the parties intended to decide to opt for the international rules or the AAA in the first place, and the respondent objects to the administration of the case by the ICDR. That will go to the Administrative Review Council to decide whether they will accept the case and administer it, or whether they will invite the claimant to go to court and seek an order. They will also decide issues if you challenge an arbitrator. They will review the party's submission and decide or not whether or not an arbitrator should be challenged based on lack of competence, or more commonly lack of independence, impartiality, or incomplete disclosures. And the little point on the final bullet point here, the review of the award, it's not a substantive review. It's purely a formal review to make sure, I assume that the arguments of the parties are properly explained, that there are no new arguments that are analyzed by the tribunal that parties did not submit. We're talking about procedural and formal review, but the institution cannot second guess or question the substantive findings of the arbitrator.
No, thank you. Yeah, maybe Yasmine, my example was not good, like comparing to a police. I think you do that. Thank you. Thank you for bringing the examples. And regarding, we have the Article 22, the tribunal authority and case management. So the tribunal has broad discretion to conduct arbitration in a manner it's considered appropriate, ensuring fairness, efficiency, and economy. So the tribunal may address preliminary issues at an early stage. The tribunal can also bifurcate proceedings, direct the order of proof, exclude cumulative or irrelevant testimony or evidence, and require the parties to focus in submissions or issues whose resolution may dispose all or part of the case. And another article that I want to bring here is the early disposition. So the ICDR rules expressly authorize early dispositions of claims or defenses that are manifestly without merit or outside the tribunal's jurisdiction. Provides a powerful tool to streamline proceeding, reduce costs, and avoid unnecessary evidentiary phases. Yeah, and this is interesting because I recently had a default judgment in one of my arbitration cases. So this, I think this is a tool that parties should know that exists in arbitration as well. Do you want to add something, Yasmine, in this slide?
I think if you read Article 22, you will see that the ICDR rules are quite unique in their explicit endorsement of the extensive authority of the tribunal to organize the proceedings efficiently and effectively. And if the parties agree on something, the arbitrator is unlikely to do something against the parties' agreement, because then there's a risk of vacature. But also, when there is a procedural disagreement, this provision, Article 22, justifies the tribunal's use of its power to conduct the proceedings efficiently. It avoids what's so-called due process paranoia, where the arbitrator will allow a party to present all the arguments, to seek an additional hearing, etc., where it's really not necessary, where each side has actually had the opportunity to present their evidence, and there is no need for more evidence. There is no need for hearing, for example, because there are no witnesses. And this is the basis, Article 22, for the arbitrators' authority to conduct the proceedings as they see fit. And under that provision, the courts look at that provision when parties seek to challenge an award because the arbitrator rejected their request for a 20-second hearing, and that says that you, the parties, agree to give that sort of authority to the tribunal, and it cannot now second guess it. And it looks like you have, in any event, had the opportunity to present all your arguments and evidence, and so there is no basis to challenge the award. That's all.
Thank you.
I think it's me now.
Yes.
So as Fernanda said, it all starts with a properly drafted arbitration clause. There is a saying that arbitration is a matter of consent, and that consent is found in the arbitration clause. You can, of course, also agree post-dispute to arbitration, but it's very rare that parties agree to anything after the dispute has arisen. So on this slide, we have really identified the must-haves in your arbitration agreement and the can-have in your arbitration agreement. One is you clearly express that the arbitration, that the dispute shall be arbitrated. And that says two things. One, that you are opting for arbitration, and you are doing so to the exclusion of another dispute resolution method, such as litigation. You also have to say what is the scope of the arbitration agreement, and the wider, the broader the scope, the less likely you are to have then disputes about whether or not the arbitral tribunal has authority to address tort claims or fraud claims that are not technically contractual, but are related to the contract. That, as I said, the arbitration agreement must show that you're opting for arbitration to the exclusion of other mechanisms. You should identify the institution in the arbitration, or it will make it very hard otherwise to have an institutional arbitration, and ad hoc arbitration can be complicated, and that can be a discussion for another day. You can also specify if you want 1 or 3 arbitrators. You don't have to do that because most institutional arbitration rules deal with that issue if the parties have not said anything on the topic. You can also mention the language of the arbitration, even though usually the tribunal or the institution in the first instance will go with the language of the contract under the assumption that this is what was used between the party. And finally, an important component is the seat. It's a legal, it's a juridical anchor point for the arbitration, and you're saying the arbitration will be under the arbitration law of a specific state, and state with a big S, sovereign. And if you opt for a seat in the United States, you will be under the Federal Arbitration Act, and all the standards to vacate an award will be those found in Section 10 of the FAA, and so long and so forth. That doesn't mean that you will have to have a hearing at the seat, but this is the legal standards that will apply to the arbitration. Additional considerations is if you want to have pre-arbitration steps, if you want the parties to have a negotiation or mediation before, be careful with drafting those clauses and making them as mandatory, because then you can end up being in a deadlock in satisfying those, because a court or tribunal can decide that these are conditions precedent, and if the other side doesn't play ball, you may have some disputes. As we discussed earlier, you can decide whether or not you want to have the arbitration to be confidential, Also, if it's a complex transaction where there are multiple parties and multiple contracts, and you want to be able to have the same tribunal decide a chain of contracts with the main contract and perhaps the one with the subcontractor, because really this is what happened with the subcontractor that is causing the liability of the contractors. Whether or not you want interim measures, if you want litigation carve-outs, for example, if you want IP issues to be litigated rather than arbitrated, again, be careful in drafting these carve-outs, because the clearer the carve-out is, the less likely will go to litigation. And most of the litigation we see on pathological arbitration clauses are about unclear carve-outs. If you want more or less disclosure, you will spell it out you can spell it in your clause. If you want to opt for a fast track procedure, an expedited procedure, you can mention that. You can exclude remedies. Very often parties say that the arbitrator cannot award punitive damages. Here, actually, the ICDR rules explicitly say that arbitrators cannot award punitive damages unless the parties agree otherwise. But other remedies is that you can say that the tribunal will not have the authority to enjoin a party from exercising its business, and things like that. And finally, you can have something to address the cost, attorney's fees. Under the ICDR rules, the tribunal has very broad authority to award those things. And usually in international arbitration, the practice is that costs follow the event, that the party who has prevailed will recover some or all of their costs and attorney's fees, but the parties can agree to exclude that part. I think in the next clause, we have sort of a few comments. Be careful about the sort of requirements that you're including about the arbitrator in your arbitration clauses, because you may end up dramatically reducing the pool of available candidates, and you can leave that to the moment when you will select the arbitrator, and to have a more narrow, well-defined qualification. When you decide on the number of arbitrators, you have to think about the likely size of the dispute, the likely complexity of the dispute, but you have to know that for smaller disputes, you really prefer one arbitrator because it's less costly, it's a third of the price, and also because when you have to schedule or reschedule hearings, it's much easier to reschedule based on one arbitrator schedule than three. And very quickly on the fees of the tribunal, on what Fernanda was saying earlier, each arbitrator set their own fees, but the fees of the entire tribunal are paid in half by the parties. If you appoint an arbitrator and he charges more than the other, it doesn't mean that you pay only that arbitrator's fees. Each side pays 50% of the entire tribunal's fees, and the tribunal does not get involved in those issues. The ICDR handles that. If a party resists paying, usually the tribunal doesn't know which party resists, to avoid sort of tainting the view of the tribunal based on that. If the parties have not agreed at the start of the arbitration on what arbitrator they want, or they don't want to do that, then you go through the process that Fernanda described earlier, into sort of a list method, and the list consisting of arbitrators that the ICDR will have prepared based on the features of the dispute and what the parties discussed during the administrative conference. In the slides a few minutes ago, where Fernanda was talking about why choose the ICDR, who will both administer international cases under the ICDR rules, but also international cases under other rules, is that, in my view, the roster of the ICDR is better vetted than other AAA rules rosters. So that's also a reason why the ICDR is more attractive as an administrator of your case. You want to go to the next slide? So we'll just leave you with this very simple clause that you can find on the ICDR website. To me, small is beautiful, and everything that is not addressed here can be and will be addressed either by the institution or by the arbitral tribunal. But the building blocks, going back to what we were saying earlier, is really that you really have to be as broad as possible. And you see the controversial claim arising out of or relating to. Courts in the US consider this to grant a broader authority to the arbitral tribunal to decide disputes that are even incidentally related to the contract. The shall be determined is the expression that the arbitration is mandatory and to the exclusion of other dispute resolution methods. And then you identify the institution and the rules. You don't need to identify the seat. You don't need to identify the language. So long as if you have those building blocks, then the ICDR, when they see a contract with that clause, they will accept to administer it without any question. So, as I said, unless you have counsel to walk you through a complex arbitration clause, or you're able to use a tool that Fernanda will describe to you in a few minutes, go with a simple clause. The final phase of the arbitration is when the issuance of the award, and really going back to what we were saying earlier in this presentation, an arbitral award presents the attractiveness of finality and enforceability. An award is the final determination of a dispute, and it is binding on the parties. Unless you use the option of appellate arbitration, which is very, very rarely opted for, and it is not available under all institutional rules, there is no appeal on the substance of the arbitral award. And what the arbitrator decided is the final decision. The limited ground, the grounds to challenge the validity of an award are extremely limited. They can never touch the substance of the decision, but only issues of due process, issues of whether the arbitration was within the scope of the arbitration clause or not, whether a party was actually a signatory or a party to the arbitration clause, because there's a lot of arbitrations involve non-signatories, and things of the sort. So it's very, very narrow. And in an international context, I think there was a recent survey, and in New York, only 2 awards were vacated in the past 5 years. That is extremely exceptional. And to ensure the validity of your award, it's essential that the arbitrator meet due process standards. Next. In addition, you're able, going back to what we were saying earlier, to have your award enforced in over 170 jurisdictions. Under the New York Convention, the grounds to refuse enforcement of the award are extremely limited. Again, validity of the lack of due process, validity or outside the scope of the arbitration agreement, public policy, which are generally extremely interpreted in a very narrow sense. Also, if the dispute is addressing a matter that is non-arbitrable under the law of the state of enforcement. In the US, everything is arbitrable, except usually domestic relations, for example, but antitrust, employment disputes are arbitrable. This is not the case in all states, and that can be a limitation to the enforceability of your award. Usually when you opt for a well-recognized institution such as the ICDR, you have at least the comfort that it was administered in a transparent, neutral fashion, and that the rules are globally recognized by courts around the world to provide a fair process. A quick point also on that is that there's a very important provision in the rules. It's the waiver, and it says that if there's a violation of the rules that happens during the arbitration and you have not objected to it at the time, you are considered to have waived it. This principle reflects a principle in the ancestral model law and also under the U.S. Federal Arbitration Act as interpreted by the courts. And it's really, if you have a complaint to be made about something that happened in the arbitration, if you did not raise it at the time, you are considered to have waived it. This is an important signal to object if you've considered that you have a serious ground to question the conduct of the arbitration. Next. It's to you, Fernanda.
Yeah, thank you, Yasmine. So even that we are 100 years organization, we are very committed and worried about the future. So within the AAA CDR, we have a AI lab. It's like a AAA innovation lab, and we are working with some innovation initiative and technology to enhance the arbitration process and system. So I'm going to bring some highlights that I believe is very important for the parties to know they are available. We have a mobile, despite the online case management system that we have a mobile app, so the parties can have access to the e-center and web file for case data access. So they need to check the case, they have access through that. We also have the clause builder, the tool that Yasmine was mentioned, that can help the parties to draft a very good clause. So this tool is IA-powered tool that leverage advanced artificial intelligence to streamline the creation of arbitration and mediation clauses. So this is a free tool that we have in our website. And I will provide with the materials here so you can try and see how it looks. So you can, as Yasmine was saying, we provide a very simple clause that if you insert the clause in the clause builder, and you can start adding, okay, I want one arbitrator, this is the seat that I want it's covered or not. So you can tailor the clause according to your needs. We also have chatbots that help all the parties, external, internal, and that help the parties and help the case management team to get some doubts and questions solved. We also have the Clear Brief. This is AI-powered writing platform to streamline documents, document summarization, drafting, fact-checking process. Right now, this tool is only available for our arbitrators, but we are working to get this tool available to the parties, to the attorneys in the future. And it's very interesting the work it does and how it saves time. And it's very important because this is a grounded AI tool in the sense that keeps the confidentiality regarding to the documents that the arbitrator is uploading to the case. So this is, we are not training the AI here, and this is not an open AI model. This is a closed and grounded model. We launched November last year the AI arbitrator that delivers fast, cost-effective, and trusted dispute resolution. Right now, this tool is already available, but right now it's only for expedited cases. for construction and only documents. And this is a very, very interesting tool that we have right now. And because this tool, we trained the AI to do that. And this is so interesting how issue the award. For first, we trained the arbitrator with all our already awarded cases. And the award the arbitrator issued was almost exactly the same as the arbitrator at that case at the time issued the award. And now we are receiving new cases that were not awarded, right? But for now we also have like arbitrator. We also have the human factor that reviews the whole process just to ensure that is correct. But it's very impressive how it works. So yeah, I think AI is something that we cannot run from it right now.
Fernanda, if I may, is it a tool that does not involve an individual arbitrator, but you're really feeding the machine with the briefs and the documents, and you get a decision?
Yes. So the arbitrator, so we have this group, Yasmine, and thank you for your question. So we have this group of arbitrators, construction arbitrators. They just review the award to ensure that, there was any chance of a hallucination of the AI. But that's it. He just reviewed the award.
So I mean I can see the reason why we're using that word, but I don't think it will be. I'm not sure it will qualify as an arbitral award.
Okay.
I don't know where it's been tested, the issue, but in some jurisdictions, if it's not a human being that issued the award, it's not an arbitral award. So you don't have all the regime on the enforceability, et cetera, et cetera. It will be interesting to see what happens, and very possibly the arbitration clauses of the future will agree to consider that as an award or something of the like. But we need to be cautious. It's not necessarily an arbitration.
No, definitely. And that's why, Yasmine, it's just here for right now, it's just released here in the US. It's not international, it's not an international tool. Even if they are planning to do so. And another point that you're talking, so for use this tool, both parties need to agree with. So it's not something that just one party filed arbitration with the AI arbitrator. Both parties need to agree to use this. So yeah, let's see how it goes, right? Let's see what the future has for us. And then we also have the arbitrator search tool that is a complementary tool that we developed to help the case manager, the case administrator, to build the list of the arbitrators that we're going to be sending to the parties. We have our internal system that we create the list, but this AI tool, it looks for concepts. And I'm going to give an example. So here in the US, consumer arbitration, consumer issues can be arbitrated, right? So, and right now we have like mass arbitration cases. And when the case administrator is building the list, it doesn't need to search for mass arbitration experience. So their case manager can write concepts or just like search consumer and will look for similar concepts. So it's just a tool that helps us to bring more qualified arbitrators to the list of to the parties. And one of the last news that we have is the Integra. It's a partnership with Integra. This is a blockchain document certification. And this is something to not use the blue ink anymore. So this is very interesting to have the award in blockchain. certificated. And then now I'm gonna, because we're talking about the clause, how drafting a clause, I'm gonna bring the clause builder, an example of how it works. So here's a demonstration, right? What type of AAA dispute resolution. And then the clause builder AI will provide you with a template. And then after that, you can add arbitration clause options to that, like arbitrator qualifications, governing law, discovery, e-discovery, remedies. So this is, a tool available in our website. And again, this tool was the internal people from AAA ICDR that developed. Sometimes we partnership with trusted companies, but this one was trained by our case managers. So I think you're gonna have like interesting templates. Maybe Yasmine, you can take a look after and then tell me if you would use that for your cases. Okay, so this is a recording session, but Yasmine and I are gonna be very, very happy to answer any questions that you have. Here are our emails and phone numbers. So please don't hesitate to reach out, and I hope this was helpful.
Thanks, Fernanda. Thanks the Beverly Hills Bar Association, and thanks everyone for your time and attention.